Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to Reproaction's Act and Learn webinar for the month of October 2021. This month's topic is extremely important and critical as our country faces a future where access to not just abortion rights and reproductive rights, but a wide variety of civil liberties could be on the brink of being severely curtailed. Our topic today is abortion comes to the Supreme Court, what's coming, and what's at stake. So first we'll introduce our hosts. I will introduce myself first. I am Erin Matson. I use she, her pronouns. I am co-founder and executive director of Reproaction, and I am based in Washington, D.C. And I invite you to follow me on Twitter at Erin to the Max, and I'll pass it over to Ivania to introduce herself.
Everybody, I'm Ivania Woods, the senior outreach producer at Reproaction, and I live in the middle of Missouri. I've been with Reproaction for nearly 5 years, and you can follow me on Twitter at Ivania Star.
Great, thank you. So what are we going to cover today? Here's our agenda. First, we'll do a welcome. Then Ivania will give an overview of abortion in the courts. And then we'll be joined by our panelist, Israel Cook with the Center for Reproductive Rights. We're very excited to have Israel with us today. And Israel will discuss the major abortion case coming to the Supreme Court in December, Dobbs versus Jackson Women's Health Organization, pertaining to the Mississippi 15-week ban. Of course, because this Supreme Court term couldn't be bananas enough, now there is another case coming before the Supreme Court, and oral arguments will actually be next Monday on Texas's 6-week abortion ban. So we'll be discussing that today as well. Then I'll cover next steps, and then we'll do Q&A at the end. So a note about that. If you have questions at any point along the way, you don't have to hold it in till the end. Just put your questions in the questions tab, and we will get to as many of those as possible at the end. So don't feel like you have to hold on to it. And then we encourage you, if live tweeting is your jam, please do use the hashtag Reproaction for live tweeting. And we'll also be tweeting from our Reproaction account. So with that, I will introduce our organization. Who is Reproaction? So we're an organization that leads bold action to increase access to abortion and advance reproductive justice. We're deeply proud of our left flank analysis and our willingness to hold folks on all sides of the issues accountable, whether they're traditionally considered allies or opposition, and we have a deep commitment to nonviolent direct action as one of the tools in our toolbox. We are a national, all-virtual organization. We always have been all virtual, not just with COVID. And this organization was co-founded by Pamela Merritt and myself, and we launched the organization in summer of 2015. Times have changed, but the need for our mission and our style of work has never been so strong. So here we are. And with that, I will pass it over to Ivania to lead us through a historical overview.
Fantastic. Thank you, Erin, for such a great introduction. So I wanted to provide a little bit of an overview. I just used this to set up the discussion that Israel is going to have. So we could start before Roe v. Wade. Most of us already know that abortion access has been a struggle that has gone through the courts, but also gone through other means, and there's been different disputes throughout history. But I want to start with Roe v. Wade because we only have an hour for this webinar, and it's a good place to start when we're talking about what it looks like in modern America or the modern United States right now. So Roe v. Wade, the Roe v. Wade decision, of course, nearly everyone knows it came down in 1973. It affirmed that abortion access was a federal constitutional right as part of the right to privacy. So the people who are getting pregnant and the physicians that they are working with, or potentially, I guess, the midwives, like their caretakers, it's between them to decide what happens there. So prior to Roe, states were free to fully ban abortion. There were no quote unquote legal limits or restrictions on the federal government, by the federal government. It wasn't recognized as constitutional, as a constitutional right, or as the language we might use now, even as a human right. So Roe created a trimester framework. And what that means is that in the first trimester of pregnancy, states could no longer ban abortion. And they established that, which again was not established prior to that, which proved to be a huge part, play a huge part, change the game in a huge way from 73 to 92. We'll talk a little bit more about how that changed up in 92 in a moment. And in the second trimester, they basically said, the states could regulate abortion in the interest of women's health, and that's the language they used, not ours. We fully acknowledge that you don't have to identify as a woman or be a woman to get pregnant, but that is the language that was used in that legislation. So, but they were not allowed to ban it, and that was explicitly included. So at the point of viability, the states could regulate or ban abortions in the interest of potential life, except when necessary to preserve the life or health of the mother. Again, using the language that was in this decision. So that point of viability was set somewhere along like 24 weeks, but that created some issues that we're not going to get into today around being able to, like, it ties into my maternal and infant mortality work, as we talk about contingencies and how abortion fits into other aspects, birth outcomes and health of the people carrying. And it also adds to like arguments that the other side have made, continue to make. But if you're in this work, then you know about those. So just to let you know, like, so much could be said about Roe v. Wade and the precedent it set, the standard it established, but we're just hitting some high notes for you here. Next slide. So I wanted to highlight 4 cases. And there's been so many more. Again, time is limited. We're trying to make this conversation as robust as possible within the time frame. So think of this as more of a starting point and not a comprehensive analysis of abortion in the courts. So we started with Roe v. Wade, but that same year, Doe v. Bolton was also a decision that came down from the Supreme Court. And like Roe, it also held that a right to privacy encompasses whether a woman will terminate or continue a pregnancy. And it was in alignment with Roe, but it just clarified it because clearly a case was brought up and they had to, I guess, like, rule again. These little nuances that antis like to bring up. And so it wasn't long, like it was the same year, right? So clarify that there. And then the case that I mentioned earlier, when that trimester standard changed, was with Planned Parenthood v. Casey in 92, which abandoned the trimester standard set up by Roe v. Wade and adopted this notion of undue burden. And as you can see here, it severely curtailed the Roe decision and created this undue burden standard, which allowed states to create substantial abortion restrictions so long as they did not create an undue burden. Now, Planned Parenthood v. Casey, this particular case, it opened up the field. If you've been in this work or not, if you've been following along at all, then you know that this was pretty much the beginning of what I would refer to as like this kind of quote unquote state legislatures versus the courts. It was happening before, but now is when the strategy really shifts, and they start trying to create circumstances through passing of bills or acts or laws to create situations where these cases have to go through the courts to challenge this notion of what constitutes undue burden, right? And since 92, that's where we've been. So we come up with 2007, we get to this point where the cases haven't stopped. Please do not think that these gaps in between cases are not being brought up, because they are, right? But the reason I wanted to highlight Gonzalez versus Carhart in 2007 is because it effectively overturned 30 years of precedent and upheld a procedural abortion ban. We use this language pretty commonly of abortion bans now, and we talk about trap laws, we talk about these things. 2007 should have been, in my very humble opinion, and was for some, but was not on a large enough scale, a wake-up call that work probably needed to shift and focuses needed to change movement-wide. But that was the first time that the Supreme Court upheld a procedural abortion ban. And what are we, 14 years later? Here we are. And then in 2016, a little more recent, a little more current, was people who have probably been in movement work, in reproductive justice work as of late, are more familiar with, and that's Whole Woman's Health. Not even going to attempt to pronounce that. I've only seen it in writing, have only learned about it in writing, and have never heard anyone pronounce it. But it affirmed the constitutional right to abortion, specifically rejecting an abortion clinic shutdown law in Texas that claimed to protect women's health but could not prove it. And this was the year before I got hired at Reproaction, and a part of my motivation for wanting to get into reproductive justice work. This for me in my trajectory of my movement work was a catastrophic moment that, not catastrophic, but it was eye-opening, right? It really tuned me in, because I too was one of those people who was like, oh no, Roe v. Wade is not going to get overturned. And it really tuned me in, like, oh wow, there are people who have their hearts set, like they're not going to give up. They're really going to keep trying to overturn Roe and do it procedurally in a way where it's in steps. They're going to chip away at it to a point where it's essentially overturned. And I want to say the creativity, like the innovation here to attack the clinical, like the surgical centers. I was like, oh, this is very different. But it really wasn't. It's just like, it was just the moment that I tuned into it, that I really just knew that this work was about to get wild, wilder. I'll put an ER on that. Next slide, please. And so talked a little bit about the historical trajectory and upcoming oral arguments at the Supreme Court, as we'll get into the present. And I'm just doing this, not really getting into a lot of detail into these cases. Really just want to set this up for Israel to dive into Dobbs v. Jackson. But when we originally were setting up this webinar, or when the thoughts like first came, the Supreme Court hadn't made a decision that they were going to take up arguments on November 1st. And so these got added in. And so on November 1st, right, it's a very confusing, and I'll be the first to admit that while I was researching this, that there's a lot of misinformation out there. And so to offer some clarity that Whole Woman's Health and Al versus Jackson and Al is a challenge to Texas' 6-week abortion ban brought by abortion providers. And the issue is regarding whether federal courts review the ban when enforcement is left to vigilantes rather than a state, and what that looks like, right? So that's a little bit more complex. And like I said, the abortion bans, the laws, the challenges to Roe and also to Planned Parenthood versus Casey are resulting in abortion bans that come with complexities that they expect to challenge those decisions while also stifling our ability to combat them in a clear-cut way. Yeah, I'll leave that there. And also next Monday, a part of those arguments is because in United States versus Texas, the Department of Justice suit that they brought up against Texas' 6-week abortion ban, which seeks to block the law from being enforced and presents the issue of whether the U.S. government has authority to bring this case. So you're getting, again, like, because these abortion bans are coming with the complexities that they come with and hitting so many different layers and multitudes, I'm going to say, like, they have to be attacked from so many angles. So I was really, even though it took longer than I would have liked for the Biden administration to get on that, they did. But what we are going to focus on today, and what Israel will dive into promptly after I finish running my mouth here, is the Dobbs versus Jackson Women's Health Organization, which is coming up December 1st, and it concerns the 15-week abortion ban in Mississippi specifically. So like the Texas abortion ban, it clearly violates Roe v. Wade. That's evident. But in this case, it looks very different because the courts in Mississippi and moving up to the Fifth Circuit, they actually sided in favor of Jackson's Women's Health Organization and prevented this from going into effect. And then Dobbs has just been like appealing as it's going up in Mississippi. As most of you probably know, only has one abortion clinic, much like Missouri, which is where I live. And so the situation is already dire. So when we're talking about undue burden, the burden is already beyond where it should have ever reached. This is their last effort, or not their last effort, but most recent effort to get rid of the one clinic that is operating in the state of Mississippi. So like the Mississippi has directly asked the Supreme Court to overturn Roe. And if you want to research that, you can just Google it. There's plenty of arguments there with not just Mississippi directly asking, but also senators, US senators like Hawley from Missouri and others in other states, which shows you where we are, right? And so with that, I will hush up and let Aaron proceed to introduce Israel so we can get into their discussion on Dobbs versus Jackson Women's Health Organization.
Thank you so much, Ivania, for that overview. Really appreciate it. And I'm certain our listeners too. So thank you so much for grounding this discussion. Now we'll be joined by Israel Cook, who is a state legislative fellow at the Center for Reproductive Rights. We're so thrilled to have Israel with us today. Israel joined the center in 2020 and is responsible for tracking and analyzing reproductive rights legislation in all 50 states and Washington, D.C. Israel served as an If, When, How Reproductive Justice State Fellow at Sister Reach in Memphis, Tennessee. Shout out to Sister Reach. We love Sister Reach here at Reproaction. where Israel was advocating against abortion restrictions in the Tennessee legislature. Israel received her JD from the American University Washington College of Law and her BA in Sociology and Anthropology from Transylvania University. So Israel, first off, I just want to say thank you so much for joining us today. It is an absolutely bananas, bonkers time, and I've got to believe that at the Center for Reproductive Rights, it is a very busy time. So thank you so much for joining us and our listeners today.
Thank you so much for having me. It is definitely a chaotic time, but I feel like in Repro, it's always pretty chaotic. So I'm really happy to be here. Thank you.
Great. Well, I will pass it over to you. I know you've got some slides, and then we'll go through some questions that I'll ask you. And again, just want to encourage folks who are on the line, feel free to put in your questions at any point during the questions tab, and we'll get to as many as possible at the end. So I'll pass it off to you, Israel.
Thank you so much. And thank you, Erin, for that introduction, and Ivania for kind of laying the foundation. And thank you for having me. Again, my name is Israel Cook. I use she, her pronouns, and I'm the State Legislative Fellow at the Center for Reproductive Rights. A couple of housekeeping things for everyone. I have a cat. He is very noisy and very needy, so apologies if you hear him. I also live in New York on a very busy street, so if you hear some background noise, I'm really sorry. If it gets too loud, I'll pause for a couple of seconds to kind of let that noise pass. And then the third, and I think most important thing, is the use of gendered language. So most of the time I will be referring to folks in using gender neutral language and referring to pregnant people. But when quoting decisions or research that use gendered language like women, I will be using that just to, stay true to people's quotes. So yes, let's dive in. So as Ivania explained, under Casey, the state can't ban abortion before viability, which is around 24 weeks, but viability varies. And in 2018, Mississippi introduced HB 1510 that banned abortion at 15 weeks, which is a direct challenge to Roe and this the holding on pre-viability bans. So the Center for Reproductive Rights and its partners filed a case against this ban in March 2018 on behalf of Jackson Women's Health Organization, the last abortion clinic in Mississippi, to block the state's ban on abortion after 15 weeks of pregnancy, just hours after the Mississippi governor signed the ban into law. A federal district court granted emergency relief, blocking the enforcement of the ban. So the ban, or HB 1510, violates Supreme Court precedent established in Roe v. Wade, and that has been reaffirmed as recently as 2020 and June Medical Services v. Russo, that a state may not ban abortion before viability. In November 2018, a federal district court granted a request for a permanent injunction striking down the ban. In December 2019, the Fifth Circuit Court of Appeals upheld the injunction, ruling the law unconstitutional. Mississippi appealed to the U.S. Supreme Court, and on May 17, 2021, the court announced that it would hear the case. And oral arguments are scheduled, as Ivania said, for December 1st, 2021, and a decision would likely be issued between April and June 2022. Currently, abortion remains legal in Mississippi, and the ban remains blocked while the case proceeds through the courts. And the question really before the court is, are all pre-viability bans unconstitutional? Can you go to the next slide, please? So here are a couple of things about what the district court and the Fifth Circuit have said in Jackson Women's Health. So the state chose to pass a law it knew was unconstitutional to endorse a decades-long campaign fueled by national interest groups to ask the Supreme Court to overturn Roe v. Wade. The district court also said the Mississippi legislators' professed interest in women's health is pure gaslighting. Its leaders are proud to challenge Roe, but choose not to lift a finger to address the tragedies lurking on the other side of the delivery room, our alarming infant and maternal mortality rates. And the Fifth Circuit said, in an unbroken line dating to Roe v. Wade, the Supreme Court's abortion cases have established and affirmed and reaffirmed a woman's right to choose an abortion before viability. You can go to the next slide. Before, states really tried using the standards in Roe and Casey to chip away at abortion access, but never really explicitly challenged the core holdings in Roe. The same with the court. The court has taken cases that kind of challenged the undue burden standard, but never really the direct constitutional question that kind of challenges the core holding of Roe. But now the state of Mississippi is being really explicit about this challenge. In its opening brief, Mississippi explicitly and repeatedly asked the Supreme Court to overturn Roe v. Wade and to rule that there is no right to abortion protected by the U.S. Constitution. In the brief, there are quotes such as, "The conclusion that abortion is a constitutional right has no basis in text, structure, history, or tradition." There were also things saying that Roe and Casey are egregiously wrong, proven hopelessly unworkable, inflicting significant damage, decades of progress has overtaken them, and that there is no reliance on Roe v. Wade. And they explicitly asked that this court should overrule Roe and Casey, and nothing but a full break from these cases can stem the harms that they have caused. Again, this is a direct challenge to Roe's core holding that every person has the right to decide whether to continue their pregnancy prior to viability. On October 13th, Mississippi filed its reply brief with the Supreme Court, which responded to the sender and its partner's merits brief. The state doubled down on many of the same arguments it espoused in its opening brief. Mississippi is doubling down on its assertions that Roe and Casey are egregiously wrong, that this is the court's opportunity to fix its irredeemable abortion precedent. Mississippi now says this case is about undue burden. The standard reversed for abortion regulations, not abortion bans like Mississippi. And Mississippi maintains its view that no harm comes from a 15-week abortion ban, and that the abortion right has no bearing on a woman's progress, including great career achievements, family work balance, and the ubiquity of accessible and affordable contraception. Also, it pushes the argument that the court should return the matter to the people, reject viability, and review this ban as well as others like it under a rational basis test, which is one of the loosest constitutional tests for if a state is violating a right. Again, usually we're in this context, Casey uses the undue burden standard. And so you can go to slide 4, please. And so what's at stake in Jackson's women's health? So there's no middle ground here. Any ruling upholding Mississippi's ban guts the central holding of Roe and our right to make fundamental decisions about our lives, our futures, and our families. Multiple generations have relied on this constitutionally protected right to abortion to make fundamental decisions about their health, lives, and futures. The impact of abortion restrictions and bans fall hardest on Black, Indigenous, and people of color, people with disabilities, people in rural areas, young people, immigrants, and those having difficulty making ends meet, often in the South and Midwest, because they already face discriminatory obstacles to healthcare. Mississippi, as Ivania said, has one of the only remaining abortion clinics. Mississippi has the highest percentage of Black people in any state in the US. The majority of people obtaining abortion care in the state are Black. And Mississippi is ranked in the US, last in the US for the health of pregnant people and children. Black infants and mothers in Mississippi suffer from higher rates of infant maternal mortality than their white counterparts. In striking down the Mississippi ban, the district court was clear that this is a matter of racial justice and gender equality, saying that the ban is closer to the old Mississippi that was intent on controlling women's bodies and that had a history of forced sterilization of Black women. People living on low income incomes are often forced to delay accessing abortion care already because they need time to secure funds and often encounter additional financial hurdles. Mississippi is one of 12 states that has a trigger ban, a law designed to ban abortion immediately if the court overturns Roe. With only one abortion clinic left, Mississippi is already an abortion desert, with some of the most restrictive abortion laws in the country, making access extremely difficult. If the Supreme Court overturns Roe, abortion could be banned or severely limited in half this country, particularly in the South and Midwest. Almost immediately if state lawmakers act, and you can find more information about the state's protections or lack of protections for abortion access at the center's What If Roe Fell resource, and it really shows and highlights what each individual state, kind of the landscape of abortion access if Roe were to be overturned. So that's a really great resource, also very scary. Can you go to the next slide, please? So yeah, what's at stake is 50 years of precedent in the right to this right to liberty and this right to privacy that's really been established by the court. The Supreme Court has repeatedly recognized the fundamental importance of the right to abortion to a person's participation in the social and economic life of the nation, and that generations have, again, relied on this right to shape their lives and their futures. The Supreme Court has repeatedly affirmed the constitutional right to abortion, and the only thing that's really changed since then is the composition of the court. Overturning Roe also implicates many constitutionally protected rights built on this right to liberty and this right to privacy that includes the right to marriage, contraception, making one's decisions about family, and developing rights around sexuality and bodily autonomy. And really, we have seen the, we've seen that state lawmakers have taken the, taken the reins and the lead in really attacking abortion. Hundreds of abortion restrictions have passed as a result of coordinated step-by-step strategy to put abortion out of reach, even while Roe stands. This 2021 was one of the worst legislative years for abortion rights in the US. And again, if Roe were overturned, 24 states would likely take action to prohibit abortion outright. Jackson v. Dobbs really opens up opportunities for states to pass restrictive abortion laws, including banning abortion at any point in a person's pregnancy. And state lawmakers will really be empowered to pass and enact more restrictive bans that have been kept in check by Roe and its progeny. And so that was really bleak and sad. So just a couple of things that you can really do. I would suggest checking in on local, state, and grassroots organizations and efforts, working to support and fund abortions, and to advocate for abortion at the state and federal level. And that could look like volunteering, donating to local abortion funds, participating in advocacy campaigns, calling your legislators to support or oppose abortion laws. And then at the national level, there are congressional actions that can take place, including passing the Women's Health Protection Act and the Equal Access to Abortion Coverage in Healthcare and Health Insurance Act. Roe is crucial, but it is not sufficient to ensure that abortion is accessible and affordable in the United States. So having Congress pass such legislation to create federal protection for abortion is really important. So with all of that information that I quickly gave, I will turn it over to questions. Thank you.
Thank you so much. And Israel, I have some questions for you before we move over to next steps and then open Q&A from the audience. And thank you so much for breaking that down and for making it very clear what is at stake here. It is a terrifying time. My first question for you is, it would be helpful. So we now have a Supreme Court that is a 6-3 anti-abortion majority. Donald Trump was very successful at remaking the courts at all levels in the judiciary, including stacking in federal courts and not just the Supreme Court, with extremely reactionary, hostile judges to rule of law and civil liberties. So my first question is, can you just tell us, how is this moment in time different, that we have this clearly, blatantly unconstitutional abortion ban coming up from Mississippi for the court's consideration? And in 2016, with the Whole Woman's Health v. Hellerstedt case, abortion rights won at the Supreme Court. So what has changed in the last 5 years, and why is this moment so different now?
Thank you for that question. And I think one of your main points is the composition of the court and really strategy by antis. Dobbs is really the first time the Supreme Court is hearing a pre-viability abortion challenge in 50 years since Roe and the 30 years since Casey. Lower courts are usually the ones that take up these types of questions. And usually the viability line is the threshold. You see with Texas SB 8, antis were procedurally very creative. It's a very novel procedural thing that has that they introduced, and it was kind of things that like this are kind of snuck in under a procedural loophole. It's not like a lot of abortion bans. But yeah, nothing's really changed except the composition of the Supreme Court. When Justice Ginsburg was still alive, the court kept saying that it didn't need to overturn Roe or Casey. But that tune has really changed since Justice Barrett's confirmation.
Thank you for that. And what do you think, if anything, what do you think people can take away from the fact that this Supreme Court, so not only is the Mississippi 15-week abortion ban blatantly unconstitutional, and as you noted, Mississippi is just directly asking for what it wants, which is to overturn Roe v. Wade entirely. So along with this blatantly unconstitutional 15-week abortion ban, now on 2 separate occasions, the Supreme Court has this current Supreme Court has directly allowed the blatantly unconstitutional 6-week abortion ban in Texas to go into effect. And so depriving just innumerable people access to care and causing chaos in Texas and throughout the country. There are just horrible conditions for people seeking reproductive health care, to say nothing of the terrifying and chilling climate for abortion providers in the state of Texas right now. And so my question to you is, this is something we hear a lot from activists at the grassroots level, and I think it'd be helpful for them to hear it from you. What should folks take away from the fact that the Supreme Court has allowed this 6-week ban to be in effect in Texas? Does this mean bad things for the Jackson Women's Health case, which they will be hearing this term? What should people think about the Supreme Court that they're allowing this law to go into effect?
Yeah, I think that, Justice Roberts tried really hard to keep the court apolitical, whatever that means. And I think these cases and this willingness just highlights the politicized nature of the court. And I think that's something that a lot of, activists and advocates already knew. And there was just kind of this facade of this apolitical court. And so I think that it's just kind of underlying what we've already knew and what we predicted, and really using that to maybe push more federal actions to protect access and to really, think about what proactive advocacy looks like on state and local levels. But it kind of, I think that it's kind of what we already knew. It's just, more out in the open and more blatant, especially with the change of the composition of the court and, Trump's blatant, statements around padding courts to overturn Roe.
Thank you for that. And you know, to talk about Roe, another thing that we hear a lot from our activists and people who want to take action with Reproaction. So the fact is, yes, abortion is still legal in all 50 states, including in Texas, prior to 6 weeks, although that's an incredibly difficult and punitive time frame. Um, but and Roe v. Wade remains the law of the land today. However, in activist circles and beyond, just from the reality of people seeking care in the United States, the fact is that Roe has not guaranteed access to abortion care for everyone. And in fact, it's a real struggle for people to access abortion care for a variety of reasons, including where they live and access to care, to laws that have been put in place purposefully to make abortion care more difficult to achieve. And of course, funding of abortion remains something that's very difficult for many, many people, where it's a choice between groceries and making a car payment, or getting the care that they need so that they can live their lives as they see fit. And so, you know, one of the statements I hear sometimes is that Roe is the floor and not the ceiling. And that's absolutely right. Sometimes I think people get frustrated because, for practical purposes, Roe v. Wade fell a long time ago for a lot of people in this country, in terms of a lack of access. So, but there's some nuance here, right? That this is an incredibly important decision and that we need to protect it and expand upon it. So I just like to hear you talk some more about why protecting Roe is so important, even as we know that people are struggling to access care with Roe as the law of the land today.
I think what you said is really correct. Roe is a baseline, but also, without going too deep into like the liberty doctrine, which the center does have a resource on kind of this doctrine around liberty and the right to liberty and the right to privacy. I think, one, it's a baseline that establishes I wouldn't say clear test, but a test for laws that are restricting abortion access, guaranteeing pre-viability abortions, but also it implicates a lot of other rights that have be established under the liberty doctrine and the various right to privacy cases and rights that have been created. And so it really, to overturn Roe, it's like intrinsically linked to all of these other rights, like marriage and, you know, the right to make decisions about your family. And so the court is really kind of stepping in a mess here, because there are so many rights that are implicated in this, if that makes sense. Yeah, I mean, it's just further, even though we know a lot of places in the country are living in a post-Roe, you know, reality, it is a baseline and a way to measure, you know, access to, you know, essential healthcare. I don't know if that answered your question, but that's kind of the thoughts that I was having.
That does answer my question very well, and it's very helpful. Thank you. And so this is the last question from me before I move to next steps, and then we'll open it up to general questions from the audience. So my question is, what are some ways that folks can support abortion access right now in this absolutely critical time before the Supreme Court, and to stand up for abortion rights?
I think one of the most important things is keep talking about it, because, you know, a lot of these things start at grassroots level, where like who's being elected, who's advocating for or against abortion access. So continue talking about it, and really framing it as, you know, unstigmatized and a fundamental right, and, you know, really essential, necessary healthcare, you know, but also make sure that you are connected and in contact with local and state level organizations that are doing this work. They have, you know, built campaigns and programs that are working towards, having abortion as, protecting abortion as a fundamental right. And so really plugging in on a local and state level to organizations that are doing the work. But then on a personal level, I think just talking about it in an unstigmatized way. I think, the big picture really gets people, bogged down. And so I think that's something that I would talk about. And if you want more macro things, call your state legislators, really, work to push Congress to pass federal protections.
Thank you. Thank you so much for that, Israel. Okay, so I am going to, I'm sorry, I never brought up your timing and next step slide, Israel. Do you want to talk through that with this on the screen?
No, I already talked about it. It was just to, kind of lay it out in a more succinct way for people to see, just to see what the timelines look like and that, super important December 1st oral argument date.
Thank you, and I'm very sorry I botched that. Appreciate that. I'll leave that here as I'm talking and going to the next one so everyone can see it visually as well. Israel did talk us through that, so thank you. And now I want to encourage everyone to plug into Reproaction campaigns. So we do these Act and Learn webinars every single month. They are free. They are open to the public. We want you to come, but the only way we can send you your invitation is if you sign up for email alerts at reproaction.org. So go to our website and do that. And please do follow us on social media. We are Reproaction on Facebook, Twitter, and Instagram. We will most definitely be outside the court on December 1st for oral arguments on Dobbs versus Jackson Women's Health Organization. We will be out there loud and proud with our abortion is unstoppable messaging. So if you want to take action with us and go outside the court or follow along online, again, get on our email list and we'll be sending out more information on how you can stand with a variety of organizations who are standing up for the right to abortion that day. Additionally, I want to share that a lot of our work, we recently led a self-managed abortion with pills teach-in outside the Supreme Court. I want to be very clear that it's not either or, either self-managed abortion with pills or we get to have in-clinic abortions. It's both and we're advocating for more information and more access to both. But we've got a really amazing campaign about that. So you really want to link up with us, and we look forward to continuing the conversation with you. And also, please save the date for our next Act and Learn webinar, which will be on Monday, November 16th at 12 Eastern. It'll go 1 hour, just like this one. And our next topic will be foreign aid and abortion. So we really look forward to seeing you next month. And with that, I'm going to open it up to Q&A. The first question that came in is that noted that SCOTUS will be hearing oral arguments beginning on November 1st. That is on the Texas abortion ban. Specifically, they'll be hearing at 10 a.m. They'll be hearing the Center for Reproductive Rights suit with the abortion, that Center for Reproductive Rights representing the abortion providers, and then at 11 they'll be hearing the Department of Justice's suit, as Ivania covered earlier. And the question was, how long can we expect those arguments to go on for? They will last for an hour, but Israel, I think this would be really helpful because the Supreme Court is kind of this mystified thing for all of us, and I include myself in that who didn't go to law school. So what happens at oral arguments, and then what happens next after that to the Supreme Court? So is it that there's more days of arguments, or do they go back and confer? Like, what should people expect? How does that general process work?
So as someone who went to law school, and some of these procedural things still mystify me. So it is not just people who didn't go to law school. It's very confusing, and it's prohibitive for a reason, to really keep people out of the process. Usually, it is those first arguments. Sometimes they schedule additional ones, but the court will deliberate and, you know, issue its judgment or order. So it just really depends on the timeline. I'm unsure of the timeline for these two decisions, but it could take months. It could be, we could be waiting for something until like early summer, but it just depends on when the court decides it wants to act. I will say that just keep up with, you know, the center's press releases, because as things become more clear or that are given clarity, we do usually release press releases that have specific dates that are coming up.
Thank you for that. Really appreciate that, and all the expertise of the center, as well as you as our special guest today. So this is a great question, and another one that we hear a version of a lot. The questioner thanks us for hosting such an informative webinar, and is wondering, as abortion access throughout Mississippi and the whole country hangs in the balance, what role might emergency contraception have to play?
I think it plays a very important role, and I think that this kind of is a great segue to kind of, you know, thoughts about reproductive justice and how there are so many aspects of our lives and our healthcare decisions that really shape what our, you know, decisions and futures look like. And I think emergency contraception plays into that a lot. But it's only one factor. I mean, you think about maternal health, like what are your access to pregnancy resources? What in your ability to access maternal health care and, you know, feel safe throughout that process or survive that process. So there's a lot of things that are implicated by, you know, Roe being overturned or not having access to abortion. Emergency contraception being one of those things, and a lot of great activists and advocates around that. And I think it's similar ways to support them similarly to abortion access, and that is, you know, connecting to, you know, grassroots organizations and campaigns to really see what the needs are and what your action items can be. Hope that answers the question.
Yeah, no, that's great. And I'm going to add a little more as a point of personal privilege, because we hear a lot about this at Reproaction, because we, as I said, we've been doing a multi-year campaign on raising awareness about self-managed abortion with pills. And we do things like house parties where we get together with groups of folks and we go in depth in the World Health Organization protocol for safely and effectively ending a pregnancy with abortion pills, which is very much doable, by the way. And there's reams of data from overseas showing that where abortion has been totally banned, that shows that people can do this safely and effectively, and they do, and they're already doing it here in the United States as well. And in that scenario, I want to also clarify and put a finer point on the word safe. It's medically safe. The primary risk of overturning Roe as far as self-managed abortion is concerned is legal and not medical. People are already being criminalized for pregnancy outcomes, including abortion and miscarriage, and we can expect that to get much worse as if this Supreme Court continues on the path that appears to be headed. One question that we get a lot is about emergency contraception, and I want to say very clearly that emergency contraception and abortion pills are two separate things. That emergency contraception will prevent a pregnancy from taking place, right? If it's used, it's emergency contraception pills. If it's used in a time period, usually it's something like 72 hours is the best practice of that window. As soon as possible, though, after sex, where a person thinks that they may have been lacked protection from pregnancy, that it can prevent a pregnancy from taking place. But emergency contraception is not going to work like an abortion pill. It's not an abortifacient. So taking emergency contraception will not actually induce an abortion. And that's really important because while it won't hurt someone to take emergency contraception, what it could do is delay their access to getting the abortion care that they need. So abortion pills are not emergency contraception. So, you know, sometimes there's well-meaning headlines like, oh, let's stockpile emergency contraception pills in response to this hostile Supreme Court. And that's kind of well, first of all, we want to make sure that people are able to buy or access emergency contraception when they need it. But also that's not going to solve the problem. So it's definitely an important part of the dialogue, but it's not a replacement for abortion. I want to share this question that comes in and just makes my heart sing in all the ways. I'm smiling so big. The person says, I'm a high school student in Kentucky. Yes, love high school students on our webinars. And the person says, first, I just want to say thank you to all of you who are fighting for the right to make reproductive decisions. The situation surrounding abortion rights seems really dire, and I am both fearful of possible bans, but would really love to help you anyway. Are there specific actions I can take to fight for abortion rights or volunteer opportunities with Reproaction that I would be eligible for? Again, you guys are amazing, and thank you for all you do. Okay, so first of all, thank you. You are amazing. Thank you so much. You're in high school, and you're on our webinar, and you're caring about a more just and fair society, and I'm really, really glad to have you here. Really support young people's leadership in this important struggle. Yes, absolutely. Please plug in with us. Join our list at reproaction.org, and we will do that. You'll be in touch and you won't miss a thing for any further opportunities. And we'd love to chat with you more about self-managed abortion with pills. I'll just open it quickly to Ivania. Anything else you'd like to say as our senior outreach producer to this awesome high school student?
No, I was going to say like perhaps email Reproaction so that direct communication can happen, and maybe some guidance around what to read, what to look at, and how to get involved directly.
All right.
Yeah.
Awesome. Thank you so much, Ivania. Oh, come on in.
Sorry, I was going to say shout out to Kentucky. I'm also from Kentucky.
Woohoo! Kentucky, the hotbed of the abortion leadership we need. So awesome. Love it. Well, I want to say thank you so much, Israel. You've been a really provocative panelist, and I know you've spread a lot of knowledge today. I also want to give my profuse thanks to Ivania Woods for pulling together this webinar today. It's been really important. And thank you to each and every one of you for attending. We'll look forward to seeing you again next month, as well as out in front of the court or online for oral arguments. Thanks so much.